Abolition. Today.
In terms of what I plan to focus on, I was asked to talk about two of my articles that I guess kind of span a spectrum of my writing about race and the law. So the first one is called a 13th Amendment Framework for Combating Racial Profiling. And that one, I think, was published maybe in 2004, 2005. It was one of my first big articles. And that one looks at the issue of racial profiling through the lens of the 13th Amendment and through a lesser known aspect of the 13th Amendment, that it prohibited not only literal slavery, but also what its framers called the badges and incidents of slavery. Those modern day conditions that are a legacy of slavery or that were an outgrowth of it. And so in that article, I argue that a wide-scale system of criminal suspicion based upon skin color is a badge or incident of slavery because it mirrors, even if not driven by the same purpose, the kind of racialized control over autonomy and freedom of movement that Black slaves, as well as all free Blacks, were subject to during slavery. So I'll talk a little bit about that one piece, and I know that David and Jalila will have a lot to contribute there because of their own work about race and the criminal law. The other piece is much more recent. In fact, it's still a draft. It's been accepted by the Texas Law Review, but hasn't been published yet. It'll come out next year. And it's about freedom of speech and slavery. So the idea of that one, again, kind of drawing on the legal history of slavery, is that, in my view, as well as in the view of many other scholars, we have two distinct constitutional regimes. There's the framing to Civil War regime, right, the 1787 to 1865 Constitution, which I'll call the original founding. And then there's what's referred to as the second founding, the post-Civil War constitutional amendments, as well as federal civil rights statutes, that the people at the time who adopted them thought of as representing a second American Revolution, a second founding of the nation, in turning away from a society based on racial slavery to one who, at least in its fundamental charter, would be based upon freedom and equality for all persons, not merely a subset. In constitutional doctrine, as you'll recall, the cases, and indeed I would say probably most professors, spend very little time talking about the second founding as a new constitutional moment. We talk a lot about specific provisions from the post-Civil War Constitution, right? So you spend a ton of time on equal protection, due process, privileges and immunities, etc. But in general, when we talk about the pre-Civil War Constitution, we tend to act as if the second founding moment never happened. For purposes of this paper, I contend that courts tend to act as if what freedom of speech meant in 1791 when the Bill of Rights was ratified is exactly the same thing from an original meaning perspective as what it should mean today. And my point is actually not so much to kind of claim or disclaim originalism. It is simply, if you're going to analyze the Constitution from an originalist perspective, there is another originalist moment where the original framers' view was modified, elaborated upon, and in some cases rejected by the second framing. And so the article in one sense is kind of a theoretical plea that we take the post-Civil War Constitution seriously as a second founding moment. The second, more specific part is, if you accept that frame, which certainly not everyone would, what might it mean for how we interpret some specific constitutional provisions? And one of those is the First Amendment. So the, I think, kind of most novel contribution that the article makes is that it looks at freedom of speech, not just through the lens of the first founding framers, nor exclusively through the lens of the second founding framers, but that actually foregrounds the views of enslaved persons themselves and asks, what did freedom of speech mean for them in a condition of slavery? What denial of their free speech rights did they experience? What would they have hoped or expected the post-Civil War vision of freedom of speech to entail? And I argue that as part of the constitutional polity that would help us understand the general public meaning of freedom of speech under the post-Civil War Constitution, that the voices of enslaved persons have been almost entirely ignored in constitutional interpretation. So I draw from a lot of first-person slave narratives, where the slaves talk about their experiences with being denied freedom of speech and talk about what they think it should mean under the Reconstructed Constitution. So I'll be talking about those in the talk, and hopefully folks will find it interesting. But I think what all of my 13th Amendment work, including this most recent piece, are trying to do is to show there is a different constitutional legal history that has largely remained untold, right? That particularly the post-Civil War Constitution was one that was about equal dignity and equal worth and about freedom and liberty in many aspects. Some of them were liberty of body and movement, which is the racial profiling piece. Some of them are liberty of mind and conscience, right, which is the First Amendment piece. But the animating impulse is the same, that, there's a long debate about whether our Constitution was originally pro-slavery or anti-slavery. And my point, I guess, the intervention I make in my work is that in seeking to answer that question, we have to look at our Constitution as a whole. And too often our courts and lawyers act as if the post-Civil War Constitution didn't really happen.
Abolition today.